recommendation, which is pursuant to the memorandum we received from His Excellency the President, making certain recommendations. First and foremost, it's important we clear the air, because there is anxiety, there are fears that the President may actually be initiating some constitutional reforms or amendments similar to the BBI, which was rejected. It is important to point out that there is distinction between the BBI and the memorandum we have received, in that the BBI clearly was an initiative of the President and the Executive. The Gazette notices that were initiated the process were signed by His Excellency the President then, while he went ahead to constitute the committee that came up with a proposed constitutional amendment. As far as this is concerned, what the President has done is to make recommendations in his capacity, his two capacities. The first one being the President of the Republic of Kenya, and he is entitled to do so on behalf of the people of Kenya who elected him. Number two, also as a citizen, and he has a right to do so as a citizen, to make proposals to this House to consider parliamentary initiative or a popular initiative, whatever it is that has to be considered. The memorandum talks about 4 issues, the first one being the 2/3 gender rule, very important because of the constitutional article which exists, that if this House does not enact laws relating to the 2/3 gender rule, then it stands dissolved. Now, it is important to remind the House that the former Chief Justice Maraga actually made the advisory that the House, the 12th Parliament, had to be dissolved because it had failed to comply with that constitutional provision. Fortunately, it wasn't, but that is the farthest it went. It remains law in this country, and if we do not follow what the Constitution says, there is that risk. The second one relates to the CDF, the Govt, and the Senate Fund. We've already debated extensively regarding this, the importance of those funds and why they should actually be entrenched in the Constitution. The third one relates to the office of the official opposition leader. And this is where there are jitters as to whether we are creating an office for somebody. There are arguments that this House cannot amend the Constitution to comply with that proposal. One reason being given is that our country follows what is known as the presidential system of government, while in areas where, or in countries where we have the official opposition leader, the system of government is parliamentary, as found in Australia, found in England, or UK, Canada, and such other Commonwealth countries. I do not personally agree, and I'll be persuading my committee, the Justice and Legal Affairs Committee, to see it from a different perspective. That even if we do have a presidential system, there are bits and pieces that marry our system with the parliamentary system. It's those bits and pieces that we are going to exploit, that we are going to use, so that we are able to bring in this office. The importance of the office cannot be overemphasized. The reason being that the person who comes number 2 after a general election is a very important person. And this is for posterity. It doesn't have to have the last elections in mind. That person has a lot to contribute when it comes to checks and balances of the government. It's also important to know where to find this person. For example, now, 2 of these issues have been referred to my committee, Justice and Legal Affairs. We would want to hear from the leader of opposition exactly what his views are. But as we speak today, we do not know where to find him. We do not have to go to rallies to find him. If we go to Capitol Hill, where he used to be the last time, possibly to be said we are going for Mwosho Moja. So, where do we find him? Where do we take his views from? Do we meet him in one of the committee rooms in Parliament? That is dishonorable. From now henceforth, we should consider according that office the respect it deserves, so that the occupier, who is going to be anyone ranging from the members of parliament who are here and others who will be elected in the future, can actually sit in that office, can be consulted on all matters that may come into deliberation in this house and in this country. Two of the matters are committed to Justice and Legal Affairs Committee, and I confirm we will move with the expedition to actually determine them so that this committee has a house. I know for sure we have to do a public participation. We have to go around the country as members of parliament and members of that committee, obtaining views from Kenyans. And here, what we are dealing with are proposals. Kenyans can actually reject these proposals in total. If that happens, it's for the good of the country, it is the will of the people. If Kenyans agree that parliament should consider, then we will move to the next level to determine whether these are parliamentary initiative amendments or they are popular initiatives, which means we have to go to referendum, and we will require a referendum law to actually guide us. We do not have one at the present moment, but we should be looking into having an act of parliament on referendum, because we have said it before in the 12th parliament, we do not know how to operate or how to actualize a referendum without the law. The Supreme Court has also pointed out to us regarding this. And finally, we have the other recommendation made by the President, which is that cabinet secretaries do come to the House to answer questions. And there are, again, a jitters, anxiety that we are bringing strangers into the House. We are also contravening the law that this is not a parliamentary system where cabinet ministers are members of parliament and can sit in the House and, and deal with matters relating to the executive. Our position, as I said again, it's barring the two, because when we brought the 2010 Constitution, we allowed two strangers expressly to come into the House, address the House, and whatever they propose is acted on by the House. The first stranger who comes in is His Excellency the President. He actually has that mandate from the Constitution. He comes over here to make the State of the Nation address, and we debate that address thereafter. And we actualize some of the views he gives to us in the form of laws, regulations, and motions. The second person who comes over here is the Cabinet Secretary in charge of Finance. Again, this is given by the Constitution. He comes over here, he gives us the budgetary estimates after Parliament has looked at them, as we are doing now, right from the supplementary budget to the budget policy statement, which has just been tabled, and eventually the parliamentary estimates. This is provided by the Constitution. Nothing stops us as the House with our handmaidens and the standing orders, as I heard Honorable Nyikal saying. Standing orders are handmaidens of this House. They are not cast in stone. That is why at all times we have what is called the saving provision of the standing orders, which gives the Speaker the power to rule on anything that is not provided. And that's a standing order number one. But in this particular case, we have standing orders which we can amend. And after the amendment, for sure, what is going to happen is we are able to allow cabinet secretaries to come here and answer questions. We are also able to interrogate them. We are also able to ensure that they do not get away with the escapist answers, which is what we get from chairmen of committees when they came to read statements, to read answers to questions which they know nothing about. So this is a very important motion, and I would urge the House, we debate it soberly. There are proposals, they are not cast in stone. The decision lies with the House and with the Kenyans. With those remarks, I do support the motion.
Thank you, Sir George.